would prefer you use. And, there are a lot of options. And, I always talk about the 3 goals when regards to contracts. Goal number 1 is getting it under contract. Goal number 2 is protecting the clients. And goal number 3 is to actually close. So we can do all of these different things. We can do a repair request. We can do, we can waive appraisal contingencies. We can have post-closing occupancy. But if we don't actually close, then we're wasting everyone's time and we're potentially wasting a lot of money. So never lose focus on what you're trying to do. You may do something just to get it under contract, but you can't lose focus on the fact that you still have to have a plan to actually close. Yeah, Don mentions in the chat, we won't see your video, you'll only see me. We're doing basically a webinar format to hopefully simplify things, let people sign on and just view, and no pressure to communicate, but do use the chat feature. I would love for you guys to use the chat feature. So let me share with you the form. Let's start there. Share screen. So this is F273. And this form really just came to my attention in the last couple of months, because as these multiple offers have just grown and grown and grown, has become more and more competitive, this has been something that people have looked at to gain an edge. They see it as being more beneficial to a seller because the buyer has less options to actually terminate. But I said it before everyone had a chance to join. This is not a great form, in my opinion. It has some things in here that I think are confusing or potentially leave you worse off than the due diligence period. And let's get into that in just a second. But here's the form. Make sure that you've looked at it before you actually use it. And that's what we'll do in this class as well. But that's the most important thing. I needed to look at it before I could actually give anyone any advice on it. This is form F273. So down here at the bottom, F273, this is the newest version as of January 1. Yeah, and Eric, it can be worse off for the seller. So let's talk about it. Let's go back to my, my spreadsheet here. So continuing from the last topic regarding multiple offers, it is proving imperative that we also consider the property sold with right to request repairs exhibit form F273, where the normal contract provides for a due diligence period, allowing the buyer to terminate for any reason, such as a free look. The repair exhibit limits that right only if certain repairs will not be addressed by the seller. How does it work? Where should we use it? Who should use it? Let's dig into it. And remember those 3 goals. Get under contract is goal number 1. Protect the clients, in this case, protect the seller. Goal number 3, close. So first, as a recap, let's look at the due diligence period. And it's right on the first page, property sold as is. Actually, this is a cutout from from further on, but it says the inclusion of a due diligence period shall, A, during its term, make this agreement an option contract in which buyer may decide to proceed or not proceed with the purchase of the property for any or no reason. And B, be an acknowledgement by seller that buyer has paid separate valuable consideration of $10 for granting the option. Now, I've done a lot of classes on actually paying real option money, but in the event you don't do that, if it's just left blank, they still are trying to create consideration. What's one of the important parts of having a valid contract, having consideration. Purpose of the due diligence period. During the due diligence period, buyer shall determine whether or not to exercise buyer's option to proceed or not proceed with the purchase of the property. If buyer has concerns with the property, buyer may, during the due diligence period, seek to negotiate an amendment to this agreement to address such concerns. And that concern, those concerns are limitless. It could be anything. It's why I would call it a free look. So then you look at section 3 there, notice of decision not to proceed. Buyer shall have elected to exercise buyer's option to purchase property unless they give notice of their termination. So that's your recap of the due diligence period. It's a certain number of days. Before we had this crazy market, you might see 10 days as a pretty standard number for a resale deal. We're starting to see, we're challenging those numbers, maybe 7 days, 5 days, or even 0. We are seeing zeros on some people who are just trying to say, hey, I'm in, earnest money is non-refundable. And then if you look at section E there, repairs, all agreed upon repairs and replacements shall be performed in a good and workmanlike manner prior to closing. So if we do agree to repairs under the due diligence period, they should be done correctly. Despite what some sellers may believe, the form encourages buyers to renegotiate if during this period they discover issues with the property not previously disclosed or understood. I think that's a really important thing. It actually says in there, if you are not happy with the property for any reason, give the seller an amendment. And that is, even if there's a special stip saying, you know, this is as is, because it is as is. This contract is already an as is contract with the right to do anything they want during this due diligence period. So that's what we've always had. That's what we've always dealt with. And the reason they have this right is really just leverage. Because the buyer has the ability to terminate during a due diligence period, they have the leverage to ask for anything. They could just terminate. They could ask for a price reduction. They could ask for anything. So, special note I put in here: the new construction form is not subject to due diligence period. I think that's a really important thing as well. And I've taught a lot of classes about new construction. They're just different. So if you're running into a new construction deal, I actually reviewed one this morning where there's no due diligence period because it's a brand new house and the builder just has to build it per the specs. And the financing contingency was only 7 days from binding agreement date. So what can you actually get done in that time period? What are you looking for? What rights do you have to leave? And that new construction contract is kind of like the right to request repairs. It's actually very similar. So F273, I'm just going to assume that most of us understand how due diligence works, that it's a free look. The buyer has all this leverage because it's a free look to renegotiate the price, the credits, repairs, closing dates, whatever it may be. So fast forward, this is a form that maybe we're not as familiar with. So how does it work? Buyer has blank days to provide an amendment requesting seller repair items as shown on an inspection report. Depending on your inspector's turnaround time, you could put anywhere from 3 to 10 days. Now that's the most important part right there. The only way you can use this form is if you get an inspection. Now, luckily, most buyers get an inspection. But what I would challenge you on is make sure that you can get it done in that time frame, minimum. So you're gonna have to do a couple things here. You have to hire the inspector, get them on the calendar, and then get the report back in time to do an amendment and send it back to the seller. So here's a cutout of the form. Buyer shall have the right to request that seller repair and or replace defects, if any, in property identified by buyer's inspector in a written report. Within blank days of binding agreement date, buyer shall provide seller with a signed written amendment to this agreement requesting the defects be repaired and or replaced, and B, a copy of all inspection reports describing those defects. If buyer does not timely present the written amendment and inspection reports, buyer shall be deemed to have accepted the property as is. A lot of people miss that. They just send the inspection report or they just send the amendment. You actually have to do both. If you don't do both, you've essentially waived your right to request repairs and now you're stuck. I've actually seen a couple of scenarios where that happened. Buyer and seller then have blank days to negotiate any repairs or credits. I would suggest no less than 2 or 3 days for this. So let's say we put 5 days for your due diligence period, your request period. So in those 5 days, you've hired your inspector, you've gotten your report, you've turned it around and requested an amendment for the seller to replace or repair all those items. If not agreed during this time, buyer or seller may accept the last available amendment / counteroffer. Buyer can proceed without the repairs, or the agreement shall terminate and earnest money shall return to buyer. So let's look at the highlights here. Buyer and seller have blank days from the binding agreement date to attempt to negotiate the defects to be repaired and or replaced, sign an amendment to the agreement regarding the same, and have it delivered to buyer and seller. If the requirements of the preceding sentences have not occurred before the end of this defect resolution period, then within 1 day thereafter, buyer has those options. This is tricky. This is really, really tricky. And if we look after the highlight, a final agreement regarding the defects to be repaired and replaced shall be formed by the first party to give such notice of the acceptance. All parties shall then promptly execute an amendment reflecting those accepted repairs. If neither party timely accepts, then this agreement shall terminate. Automatic. So here's how I think about it. You have 5 days, you get your inspection report, you send out the amendment with the inspection report to the seller. You then have so many days to negotiate if the seller is saying, hey, I'll do these 5 things, I don't want to do the 6th thing. Then the buyer can either accept that or go back to the original agreement, or the contract just automatically terminates. So let's say it was 5 days plus another 2 days to review an amendment. At day 7, after day 7, contract, if you can't agree to it, if it's not been signed, contract terminates automatically. That's a really scary thing for us because I could see it very easily just not happening. So let's keep reading. Let's, and this is not meant to scare you, but it's meant to wake you up so that if you use this form that you understand it and that you kind of calendar your schedule appropriately to know what your deadlines are. So let's keep reading. If an inspection report recommends further testing, mold testing, radon, whatever it may be, then buyer may extend the repair request period by up to 7 days. This is already written in. And this is why I don't like it for a seller, because I agreed to 5 days. That sounded great. I agreed to only repairs and things of that nature, defects. That sounds good. Only if there's a real problem. Well, it's a great house. I think it's going to be wonderful. And then we have this 2 to 3 days where we can negotiate an amendment. Now we're up to 7 days. And then if there's further testing, add another 7 days to that. So even though we've tried to limit the number of days that are available to the buyer to back out, we're now over that standard 10 days. So I don't like that. I don't like that at all. But let's read it. Notwithstanding any other provision to the contrary, in the event the inspector in a written report provided to seller recommends any additional test, study, inspection, or evaluation of any product, item, or condition in property from the time period to inspect property and the defect resolution period may be extended once by buyer, delivered prior to the expiration of the original period to inspect for up to 7 additional days. Well, I can almost guarantee you that almost every inspection report finds something where the inspector says, investigate further. Almost every single inspection report I've ever seen. And it doesn't need to be agreed upon, Don, because it's automatic. The buyer has unilateral right to do this. Again, that's why I don't like this. So this is the next problem. Let's assume the timing is fine. The house is wonderful. The inspection report, not really that big a deal. It's just tiny little thing. A bunch of GFCI outlets need to be updated. Well, how do we define what a defect is? Now, what you may have noticed, defect is capitalized. And I'll ask you in the chat feature, if you could kind of give me some feedback. Why is it capitalized? Can anyone tell me? I'll wait for you guys to answer that. So let's look at what's considered a defect. Termites and anything shown in an inspection report which, one of 3 things, is a condition which represents a significant health risk or an imminent risk of injury or damage to persons or property. That's one of them. 2, constitutes a violation of current laws, government codes, regulations, except if it is grandfathered in. And 3, is not at the present time in good working order and repair, including damage caused by termites, pests, and other wood destroying organisms. Yeah, this is a challenging definition because here's the thing, as a buyer, I could probably find things in a house that's perfectly maintained that meet one of these definitions, if not all 3. And here's an example that I struggled with because I don't know exactly how to advise you. Let's say, for example, we have a railing out the back porch, and it has spindles that are 6 inches apart. Well, this railing was built 20 years ago when the code said that 6 inches was valid. So it's been grandfathered in. So as of section 2, it's not considered a building code violation. because it was grandfathered in, it was done correctly as of the time it was installed. But what I would challenge you for, and I'm not going to say that I'm the preeminent advisor on this, I don't know the answer, but could I also say that it is a risk of injury? I have 3 kids at home and they're under 6. So my wife and I would consider 6 inches apart to be a significant risk of injury for us. Now, maybe someone who has kids that have grown up, maybe that is not a significant risk, but who makes that decision? I don't know. I would say, though, in that scenario, the best thing we can do is advise our clients of a very conservative opinion. So if I'm going to be conservative, I would tell a seller, yeah, they can request you to put the spindles back to 4 inches, even though it was code at the time and grandfathered in, because it is a significant risk. So the buyer has the right to ask for it. And if the seller says you're being ridiculous, I'm not changing that, you knew it when you made the offer. Well, now the buyer could probably terminate. But what do I tell the buyer? So I've told the seller, hey, if you don't do this, the buyer may be able to terminate. They're going to try to, possibly. So now I talk to the buyer. Let's say I'm representing the buyer side. And I say, buyer, we can bring this up, but I don't think the seller is going to say okay to it. They're going to argue that it was grandfathered in, that it's not a significant risk. They're going to say, what do you knew about this when you did your walkthrough initially? What's different? What's changed? And we're not going to do it. So I tell a buyer, do you still want this house? And hopefully they would say yes. But you can see the challenge. If we give them bad advice, if we instead say, all right, buyer, if they don't fix this, you can walk. Well, the seller may challenge us on that. And this hasn't been, really a court. This is not a court case. I don't have a whole lot of case law on this sort of stuff. And then on the other side, if the buyer brings this up and the seller says, that's not a defect, it's grandfathered in, well, who gets the earnest money? I would like to say the buyer gets the earnest. Personally, I think the buyer would get the earnest money in that case. They've made a very good argument. But if the seller fights us on it, no one wins. Everybody loses. So you can see the challenge there. So here's that form. Infestation by termites, insects, or other wood-destroying organisms, or any condition, building product, or item in which property or portion thereof identified by inspector in a written report, which, and you notice that part that said it had to be identified in a written report. 1 is a condition which represents significant health risk. Then 2 is a code violation. 3, not in good working order or repair, except other normal wear and tear. Here's the part, notwithstanding the above, all parties agree that if the existence of a particular defective product has been disclosed by seller to buyer in the seller's property disclosure statement prior to buyer contracting to purchase the property, then that defective product or any portion thereof, as the case may be, shall not be considered a defect if at the time of the inspection it is functioning in accordance with manufacturer's specs and is reasonably fit for the purpose for which it was intended. So now we go back to my example about the spindles on the guardrail. There's not a question necessarily in the seller disclosure talking about the spindles. It may talk about unpermitted work. It may talk about code violations. I don't think it specifically addresses this. And I could see where a lot of sellers wouldn't include that. They wouldn't even know to include it. You're not being asked to know what all the code sections are. So this is a challenge. But there's one silver lining. If this gets our sellers to over disclose, I'm all in. I'm so excited about that. If we can educate them and say, hey, if we're going to start requesting repair exhibits instead of due diligence, then we better disclose up front. And ultimately, I think that's better for everybody. The buyer knows before they spent a single dollar. Maybe we whittle down from 40 offers on a contract over the weekend down to 10, but those 10 are fully aware of the issues and have no real concerns, or they're willing to take on those risks and buy it anyways. I think that's my silver lining, is that if it makes us over disclose from a seller's perspective and the buyer is better educated before they even start their inspection, I'm on board for that. So some defect examples: termites. One downside of the termite thing, there's termites in a shed out back. Is that the same as termites in the house? Well, generally, no. Generally, that's not something that would be covered by a termite bond. the shed that's outside the boundaries of the house. But it could be on this property because we're talking about the whole property. And if the shed is on the property, it's part of the contract and it has termites, well, now the buyer can say, hey, you need to fix this. It's got termites, you've got to repair the shed, all this stuff. Now the seller could just say no, but the buyer would be able to walk in that case. We probably want to disclose it if that is the case. Broken appliances, HVAC. So under a due diligence period, you may notice that the HVAC's not working or that needs to be replaced or it's really old. Well, the right to request repair exhibit, you have the right to automatically do it. I already talked about missing handrails, things of that nature, not defect examples. So broken HVAC, which was previously disclosed, old electrical that was code at the time of installation, unless it's a significant safety risk. There are a lot of inspection reports where it'll say this is not to code, but is serviceable. The only times it wouldn't be is if it was like the tube wiring that's from the 40s. In that case, yeah, that would have to be replaced. It's not, even if it was grandfathered in, it's not allowed anymore. Problem areas that I see that we already kind of talked about, code violations that were code at the time that also represent safety risks. Though this could be argued, I believe a buyer could be entitled to request spindles on a handrail. There were 6 that we already talked about that. Don, you mentioned what would that include in expansion tanks on water heaters? So that's something that's been added to the code over the last several years. I don't know. I can't make a good argument that expansion tanks are a significant safety or health risk. And if it wasn't code at the time, I don't think the buyer has the right to request that be fixed. Now, will the buyer ask? Yeah, I think the buyer should ask. The buyer should throw it in there. No expansion tank needs to be added. Seller shall, replace or add in an expansion tank. I like putting it in there, but do they have the right to terminate if the seller doesn't add it? I don't know. If the water heater was added after the code was put into place, so in that case, yeah, it's a code violation and it wasn't grandfathered in. It was something that's a defect that the buyer could ask for. Ashley asks, is a shed considered personal property? No, not normally. It is affixed to the property. It might be on a foundation of some sort. I'm sure someone could argue that fact, but I think a shed, something that was actually built, not a plastic tiny little shed, but like a real shed, really could be considered property. Karen asks, can you put in your disclosure, any item grandfathered in will not be upgraded to today's code or something to that effect? We could probably think about that, Karen. We could have like a standard thing, but that's not really the purpose of the seller disclosure. It's not meant to negotiate a contract term. What you could do is you could put that as a stip in your contract, but in the seller disclosure, you're really supposed to disclose. You're supposed to tell them what the property is like. And if you're aware of code violations, you need to put that in there. And you know what, keep in mind, everybody, that you still have 30 buyers that want this house, and you can still say no to a buyer on a repair request. You're just going to take the risk that they're going to walk. And that's okay. That's not the worst thing in the world. So let's go back to my question. Why is defect capitalized? Defect, it's not because it's a HUD issue. That was a good guess. It's because it is a defined term. Now we'll see, if you look through the contract, next time you're writing a contract or doing some sort of review, taking a class, you'll notice certain words are capitalized. Buyer is capitalized, seller is capitalized, property is capitalized, closing date, earnest money, default, all these things are capitalized because what we do in contracts is that we define it once, and going forward, we just call it the defined term, almost like if it's a person. So I'll define who the seller is down when they sign signature pages, but throughout the contract, I'm not going to say Christian and Jessica, the sellers. I'm just going to say the sellers. And defect is the same thing. I'm not going to keep redescribing or defining what the defect is. I'm going to define it once, and then I'm going to use a capitalized defect in all my terms. So you can use that in your special stips, by the way. So, and that's a really powerful thing. Buyer shall. Well, buyer is capitalized. Seller shall. Things of that nature. Property. Other property. So if you have a sale or lease contingency, they call that other property. They call it other property. And so when you do a special stip, you can just say, other property shall, is no longer part of this agreement, something of that nature. All right, let's see if I can keep reading some of these questions. What if it is a estate sale when heirs haven't lived in the home for many years? Should they complete a seller disclosure with what they do know? Yes. Now, I understand you guys get a lot of pushback from sellers who never lived in the house, whether it's an investor, maybe an estate, it could be a relocation company, and they're just going to say, no, I don't know anything about it. But I taught a class for the new GAR contract changes back in January. And if you took one of those classes, I kind of made the same point that the first page of the seller's disclosure could easily be answered by anybody. When was it built? Is there a tenant? Is the property leased? Is there a valid lease on the property? Is it an HOA? Those are the questions on the first page of the seller disclosure. You don't have to live there. You don't have to be the one who owned it previously. But what can you tell me now? Do you know if it's vacant? Do you know if there's someone in there? Is there an HOA? I think we can answer those questions. I think you should be able to. And then the other part of it is there's a checklist, fixtures checklist. So what stays, what goes, specifically on that shed question, is the shed going? If you don't consider it a fixture, then that means the seller has to remove it or contract to leave it. Let's put that in the disclosure. And there is a new disclosure. So F301 is the one we're used to. F302 is a new version of the disclosure that's kind of shortened for these types of scenarios where they may not have lived there. All right, so I'm going to start looking at some of these questions. I'm going to try my darndest to get to them. Melissa asks, what if a buyer terminates because a seller says no to repair, but the seller disputes returning the earnest money, disagrees with the definition of a defect? That's the problem. I think that definition of defect is pretty vague, and I could probably get an inspector to find something in any house, even the best maintained houses. And ultimately, no one wins in that scenario because the seller is fighting for the earnest money. The buyer thinks they deserve it. Basically, we're going to go back to what I said earlier. If I'm working with the seller, I tell the seller, hey, look, I can't confirm that you will absolutely get this, but we'll make a case, right? We'll try. And same for the buyer. I can't, be sure that this is a defect. It's a little vague, but we're going to try. And hopefully we can compromise. Hopefully we could split it, or hopefully the buyer would get it so they can go buy something else. But in the meantime, the deal is terminated. Seller can move on and sell it to somebody else. Victoria asks, can seller or buyer still negotiate a monetary concession in lieu of repairs? Absolutely. And that kind of leads us to the next part that we really probably need to talk about. I don't want sellers doing repairs. I really don't. So here's what I would probably recommend. Start out by not asking for any seller concessions in the initial contract. Don't ask for a closing credit or any of that stuff, just the price. And then in your repair, knowing that a lot of these houses, let's say you're buying a $400,000 house, there are going to be repairs. There's going to be something that needs to be addressed. And instead of the seller addressing them, I would like for you to get a credit. In that case, if you haven't asked for any money up front from the seller, now you can. Because there are limits on how much money you can accept from a seller, and that's based on Fannie Mae and Freddie Mac guidelines. So if it's $4,000 coming back to me so that I can replace the deck or repair it or something like that, I'd like to be able to just ask for $4,000. I'll find my own contractor or even do it myself, as opposed to relying on a seller who's trying to do a quick close and all these other things. The money part is simpler. I would always recommend that. But you still have to send them the inspection report. So we send them the inspection report with an amendment saying seller shall contribute $5,000 towards buyer's closing costs, something of that nature. Now that leads to the next point that I want to make. I have always said that I don't think you should stop at the inspection report. You really should go the next step. And this is why I really dislike the form more than anything else, because it almost gives buyers this roadmap that I think leads them astray. I believe what we should be doing is getting an inspection and then following that up with a specialist in that field. So let's say in our inspection, we highlight 3 issues. There's an HVAC issue, there's a roof issue, and there's that handrail issue. So the handrail issue is pretty easy, but I want to talk to a contractor who can give me a quote. And now I know what I really need. I need $900 to put in new handrails. And then I'm going to go look at the HVAC thing. The inspector said that the HVAC was a problem because it wasn't insulated or it needs to be recharged or whatever it is. Well, I'm going to talk to Coolray. And I'm going to get an invoice, and I'm going to have a specialist tell me exactly what it's going to cost. It's $400 to re-insulate and charge the system, whatever it is. I'm a lawyer. I don't know what I'm talking about. The final thing would be the roof. The inspector never took a look at it or wasn't able to get up to all parts of it. So I hire Finley Roofing to go and check it for me. And they say it looks perfect. So now the buyer has some real answers. They know what it's going to cost. It's going to be, 900 plus 400, $1,300 in repairs, and then the roof is fine, so we're good. And I would love for you to be able to ask that from the seller. Can I have $1,300? Here are the invoices. Here's the inspection reports, and here's the good roof report as well. I love that, but that's a pretty normal deal, and that's how it should be dealt with. But when we start shrinking the amount of time we have to do our due diligence or our right to request repairs, we'll really start limiting our options to do it that way, the right way. So that's a challenge for me. I know you guys are stuck between a rock and a hard place, but if we can, that's where I want you to go. If you know that your inspector doesn't go on the roof, then you need to hire the inspector and a roofer at the same time for them to come in and do that. If you know that it's a really old HVAC, well, I want the HVAC company out there as soon as possible. Let's bite the bullet and do all of them. Let's do it right up front. Let's not wait for the inspection. Let's do it all now. Let's look at the good stuff, the foundation, the roof, the HVAC, and maybe, in certain areas of the city, maybe you have to do a sewer scope. Maybe you have to do a survey. I like surveys. And there's a whole nother class on surveys. So I don't want you to ever lose focus on that is the gold standard. I know it's not always possible, but that's the gold standard. Let me see if I can keep going through some of these questions. If we present a repair requirement and seller doesn't agree to everything, we can terminate and get earnest money back or renegotiate for money or price. So actually, that's kind of what this form is, but the definition of a defective item is just varies between states, between contracts. I'll give you an example. Florida, where I grew up and where I'm licensed as well. Florida, the standard contract is a repair contract. You actually have a whole separate contract in Florida that is an as-is contract that they can use. The problem with that is their definition of a defect is even different from this, because they don't define mold as a defect. They just don't. In Florida, it's pretty darn normal to have mold. And I suppose in this contract, you could say that mold is defined in this because they're saying it's a health risk. Mold is a potential health risk, although you could even have a seller argue that that particular type of mold is not. See how this gets really challenging? So knowing this really, this is a contention point. We have to just educate our buyer and our seller, say, hey, we can ask for it, but I can't make any guarantees that they won't fight us on it. And that goes to the buyer and the seller. So Melissa says to go back to the automatic termination part and explain what that looks like and how it could go wrong. So that's up in the amendment portion. The data closing shall be extended to the same. That's not where it is. Here it is. It's the last page right here under section 2. It's the last sentence. All parties shall then promptly execute amendment. So let's do a hypothetical. I'm the buyer. I do my inspection. I get the report back. It says that the handrails need to be brought back to code, that they're not code. So I make my request. I send an amendment. I send the inspection report. And I ask the seller, I say, seller shall modify the handrails so that the spindles are 4 inches apart per code, as this is a major safety risk. The seller says no. Seller says, I'm not signing that amendment. No, thank you. and they don't do anything. So let's read this last. All parties shall then promptly execute an amendment to the agreement reflecting the accepted offer or counteroffer. If neither party timely accepts the other party's last offer or counteroffer, or buyer does not elect to buy property as is, this agreement shall terminate. So the seller refuses to sign the amendment, and the buyer has a decision to make. Do I move forward? Do I basically remove that amendment and say that I'll move forward with it as is? You know, hey, it was worth a shot. I figured I'd try. I still want to buy the house. Or if nothing happens, if we're just waiting and waiting and waiting, and man, the buyer's upset, the seller's upset, contract automatically terminates. So that's how that works. There's no formal, you don't need another T&R, although you may want one. But the contract, if an amendment isn't signed or notice isn't given that the buyer is moving forward, the contract automatically terminates. Melissa, I hope that's helpful. Can a seller do a pre-inspection offered as a disclosure of the current? I love that idea. Love that idea. You could say, here's the inspection report. All the items as listed in here shall not be considered defects per the right to request repairs exhibit. We could absolutely do that. I really like that, but there's a cost. And that inspection report, the inspector is making warranties to the seller, not our buyer. The slippery slope I see there is that a buyer may say, you know what, I don't need an inspection. I don't like that idea, but what I would like instead is, let's say our seller pays $600 for a really great inspection. And I get that, I look at it, seems pretty reasonable. I see all the pictures, I've asked any questions I have. The seller's disclosure is really wonderful. It's a great house and there are 30 other offers. I'm like, all right, I gotta go in on this one. So what do? I throw in my right to request repairs exhibit, give me 5 days. And I'll tell them I'm not gonna actually hire an inspector. What I am gonna hire is an HVAC specialist, a roofing specialist. We're going to scope the sewer, and I'm going to order a survey, but it's not going to be during that time period. And say, but here's what I'm going to do. Let's do it. And I love that idea because I could get Cool Ray to come out in the next 2 days. I can get the roofing company to come out in the next 3 days, and so on and so forth. And basically, I'm piggybacking off of the seller's inspection report, but digging in deeper. I'm not just taking it at face value. I may also want to add in a mold test. So maybe I call that inspector and say, hey, what would you charge to do a mold test and a radon test? I'll throw that in there because maybe the seller cheaped out. Or maybe that inspection report is 6 months old. So I'm going to have them come back out and recertify it to the buyer. I like that idea as well. So Lauren asked it, hey, Lauren, how are you? Does this completely negate the due diligence of a walkthrough for any reason, as long as it's in the due diligence period, or would chance losing their earnest money in the next period of the negotiating period? You still have the right to inspect the property throughout the contract. So even though you don't have a due diligence period, you still have the right to have an inspector come, to have this follow-up stuff, to have contractors measure for cabinets and things like that, and to do your final walkthrough. That's separate. That's in F201. That's in the contract. It's separate from having that free look period. I hope that answers that question. Is my advice to advise our sellers to accept normal due diligence and forego 273 and buyers use the form to look better to sellers? I think I'm leaning in that direction, but we're going to finish this form here with the more practical advice that I could give you. One, I love the due diligence period because it's simple. And I'll give you an analogy of this. The escalation clauses that we talked about a couple weeks ago. I'm not worried about escalation clauses because there's rampant fraud. I don't think there is. I don't think you guys are defrauding each other left and right using escalation clauses and making up, phantom contracts just to raise the price. I don't think that's happening. But what is happening on almost every single deal is the potential for miscommunication, for this like vagueness in the contract. Well, what is the price and when, and how far is where's the cap, and what does this even mean? That's the risk. And that's the risk with this right to request repairs of it, is the vagueness and problems with the defect language and this extensions and all this, you could really raise anxiety higher than it needs to be, as opposed to, look, buyer, 5 days due diligence. I want your earnest money now, or at the end of due diligence, like, on day 3, send me your earnest money. But for 3 days or 5 days, you have the right to go in there and terminate for any reason, and I'll take that risk. I like that, because then I've really shortened the review period. Yeah, the buyer could terminate for any reason, but if they don't want to buy the house, I don't want them here. If this is an investor and they're putting offers on multiple properties, they put their offer down in the name of an LLC, then maybe I don't like that. Maybe I think that they're pulling my chain. And one other thing we could do in addition to that is, like, okay, I'll give you the due diligence for 5 days, but instead of earnest money, I want option money. I want you to give me $3,000 option money, and then I want you to give me 10 grand as earnest money. So for the right to be the one I choose, here's you write the seller check for $3,000. That's the option money. And then $10,000 is paid after your due diligence period, or like, day 5 from binding agreement date. You pay another 10,000 held by the broker of your choice. And then by the time we get to closing, you've got $13,000 down between option money and earnest money. I did give you that free look. I've given you the right to access it. But if you terminated during your due diligence period, I still keep my $3,000. I like that. I don't know if you can do that. I know you legally could do it. I know you contractually can do it, but I know that gets complex, and I'm not expecting anyone to be a superhero on some of this stuff. But that's how I would love to do it, is I ask as a seller, let's say I'm the listing agent, hey, throw down some money for option money, make it a 5-day due diligence period, and then more earnest money after due diligence. So day 5, you have to put another $10,000 as earnest money, so that by the end, let's say that was that $400,000 deal, I've got about $13,000 in earnest money on a $4,000 or total down payment, basically. So like option money and earnest money, I've got $13,000 down by day 5. That's a solid deal on a $400,000 deal. That's great. That's 3%, something like that. That's what I would love to see you do, as opposed to trifling in the right to request repair exhibit, where you could have this back and forth between buyer and seller for up to 14 days potentially. So actually, can the attorney hold the $4,000 for repairs and escrows to pay the contractors directly? Maybe. We typically do not, because the lenders have to approve it, and lenders don't want to. It would have to be on the settlement statement. The escrow agreement would have to be written in advance. I wouldn't recommend that, no. But if the work is going to be done, if it's minimal work and we can just have it paid out of closing, let's do that. But escrows are like few and far between. They just don't happen that often here in Atlanta. Tammy says, what about using the right to request repairs exhibit and then add special stip to protect earnest money if parties cannot agree on repairs? Well, I think that's duplicitous in nature. Like, you basically you're doubling the same thing. The right to request repairs exhibit is like, if you don't agree, the earnest money goes back to the buyer. Now, if instead, Tammy, you were saying that money goes to the seller, then let's just do option money. Option money is paid directly to the seller and does not get returned to the buyer, even if they terminate under a contingency. Let's see, Linda says, I was under the understanding that most sellers do not want to see the inspection report. Exactly. They, and this is a tough thing. So a lot of sellers don't want to see it. The listing agent won't open it. They're like, I don't want to see it. Don't show it to me. And I suppose the reason is that they don't want to have to disclose that to the next potential buyer. They don't want to know. They just would rather not know. And I think that's kind of ridiculous, because I couldn't imagine a judge saying, oh, well, since you didn't open it, I guess you're not liable for not disclosing. When they had the right, it was in their inbox or it was delivered to them in person, and they just said, oh, I don't want to read it. And they just never open it. So I think this contract would require the inspection report be sent. Whether they open it or not, I guess is up to them, but I would recommend they look at it. I really would. All right, so Jim says, we used to do business this way, standard, and you're right. Just a couple of years ago, they added in due diligence instead. I think it was in 2008 or later that due diligence period became standard and right to request repairs became an exhibit. Right to request repairs is stickier for the buyer, which makes it more attractive to a seller and both brokers, frankly. Yeah, I agree with that. I totally agree. No willy-nilly offers, contracts. You got to be legitimate. You got to spend money on an inspection. You could not just go under contract, not do an inspection and terminate later. You would actually have to do your inspection. You have to spend some real money. So there's a pro. I don't even know if I added that in there. Thank you, Jim. You have to mean it to use this form. You can probably still get out of it and get your earnest money back in most cases. Obviously, each proposed deal has its own merits. You nailed it. You nailed it. I wasn't even thinking about the pro of saying that, like, the buyer has to be legitimate and has to order an inspection report. And inspection reports are minimum $500 these days. I think I spent $1,000 on an inspection report. So I really love that. Jim, thank you. Betty says, my seller is to replace the roof with the insurance. The seller allows her to pick out the color. Buyer requests more few details together with roof replacement. Seller wants to follow what the insurance approved because they pay the replacement. That's a tough scenario. So that's basically the roof needs to be replaced. The insurance company is going to cover it. Who gets to pick the color? It just depends. How much earnest money down? Is it non-refundable? How far along is the buyer? Do they have contingencies? And then what color are they going to choose? If they pick green and the buyer doesn't close, the seller's going to have to sell a green house. I don't like that. So it just depends. Every context is key, Betty. Buyers don't like spending the money on those inspections, can barely get them to pay for stucco inspections. Yeah, see that, and I keep saying it in this class, you're going to run into more practical obstacles that I'm not really considering. I'll give you the gold standard, and then that's how you educate your buyers. But if the buyer says no, then you've done your job. You really have, and I've done mine at that point. If I never tell you the gold standard and I tell you to compromise on every deal, it's a disaster for you. It is a disaster for me. So let's give the buyers the gold standard. If they say, I don't want to get a survey, it's too expensive, that's fine. That's, I've explained to you the risk. I've given you options on different companies you can use, and you're choosing not to. Please let me know if you need further advice on this. That's awesome. If the same thing could go for, the HOA. They say, hey, well, is this a good HOA? And you're like, well, I don't live here. I don't really know. But I'll get any answers you may need. Here's all the documents. It's up to you to do your due diligence. It's the same thing with buyers. Bree says, in the event of a stalemate, nothing happens and contract terminates, and the earnest money defaulted buyer. Yes, but earnest money in that scenario would default as long as the buyer had a valid amendment and followed it. So if, let's say, the buyer just sent an amendment to address concerns, or the right to request repairs, right? So they send this amendment, but they don't send the inspection report. I could see a seller arguing for the earnest money, even though it terminated. For number 3, so Linda asked for number 3, defect resolution period extension. When the buyer sends a notice to extend, is this unilateral? Does the seller have to accept it? It's unilateral. All right. So let's go. There are a lot of questions. I don't know if I'll get to all of them. But let's talk about the last part of this. The fact that most sellers and their brokers believe the right to request repairs exhibit is more favorable to the seller than the standard due diligence period. But is that really true? As always, it depends on the circumstances, and context is key. So let's think of the pros. 1, limits the issues buyers can object to while eliminating the free look. So they actually have to do an inspection report, like Jim said. They have to spend money. No willy-nilly business. 2, establishes the mindset in both buyer and seller that they are obligating themselves to addressing any defects. I think this is a really positive step, where if there are repairs, the seller's on notice that the buyer's going to ask for them, and the buyer's on notice that the seller only has to address repairs. They don't have to renegotiate over price necessarily. 3, it forces the buyer to get an official inspection. I don't think we needed a ton of that, except if the buyer is making offers everywhere. 4, encourages seller to disclose, and I really love that idea. If you disclose it, it's not going to be something that they could claim as a defect later. It limits the buyer's options even further. So where seller's disclosures are typically seen as a downside, to a seller because it's opening themselves up, it's actually a very big positive. Some of the cons, so let's think about it. Parties could still argue whether the item is a defect, and the 7-day extension, I hate the 7-day extension. I just think that's outrageous. But I also understand why it needs to be in there or why it's in there. So there are always some custom suggestions that we could do this, and we've talked about that in this class. You could do a special stip saying that the handrails, though they're not code and may be considered a safety risk, shall not be considered as a defect. That all items listed in the inspection report hired by the seller and attached in, here too is, or incorporated here too to the contract, shall not be considered defects. You could do all those things to kind of combat this form, but it does make more work. And every time we customize a contract, although it's going in the right direction, it's a possibility for us to make a mistake, and I'm included on that. So some of the suggestions: remove the 7-day extension. You could just say what is this, section 3, 7-day extension on the right to request reform exhibit shall be removed in its entirety. Require any request to be submitted with an invoice. I love that. So I'm not getting just inspection report and seller shall. I'm saying, like, if you want me to address the HVAC, you need to get me an invoice. Ask the lender if you can instead ask for a credit in lieu of repairs. And again, that's the most important part. You have the right to ask for that, but the lender has to allow it. So before you actually suggest solutions to your buyer or make offers to the seller, call the lender first. And you may want to call me too. I can try and be creative for you. I can think of all the possible solutions, but what I'm always going to tell you is that you must talk to the lender before offering these to your buyer or making an amendment to the seller. So Janice, let's see if I can go a couple more of these questions. Janice had asked, on my scenario where there was $3,000 option money and then $10,000 earnest money to be paid after due diligence, who keeps the 3? The seller keeps the 3. So the seller is paid $3,000 for giving the buyer that option period, that due diligence period. Yeah, you missed a weekend, you had 30 other offers, but now you get, within 5 days, you throw it back on the market. Maybe you redisclose something that the buyer wasn't happy about, and it just goes back. Ling says that, so if the contract terminates, buyer gets the earnest money back automatically. Yes, that is correct. So yes, send. So Tayshawn says, your notes state that if the buyer and seller can't come to terms, the agreement will terminate and the earnest money will be returned. The form itself doesn't state that. How do we know for sure earnest money will be returned? Let's look at the form, actually. Pretty sure it does say in there on section 2. So here it is. All parties shall then promptly execute an amendment to the agreement. If neither party timely accepts the other party's last offer or counteroffer, or buyer does not elect to buy the property as is, the agreement shall terminate. Now, I suppose your question is in regards to, like, the form doesn't say the earnest money goes back to the buyer. I think that's implied. Now, I'm not the only attorney in the room. Maybe I am today, but in this state, and if the seller hired a really good attorney, yeah, maybe they made that argument. It wouldn't be worth their while, though. We're talking about a couple $1,000s earnest money. Most lawsuits are going to cost in the tens of thousands of dollars. And what typically happens is, if we're going to fight over earnest money, no one wins. Basically, it gets remitted to the bar, and that's where it lands. So buyer doesn't get the money back, seller doesn't get the money back. It's just really very ugly. So try to avoid fighting it. If you're representing a seller and it's close, tie goes to the runner, it goes back to the buyer. Tiana says, would this exhibit replace the due diligence placed on the purchase and sale agreement, or would you put a number of days on both? It replaces. So you'd have basically a 0 under due diligence on page 1, and you would have this right to request repairs instead of it. Francis says, in historic homes, the spool wiring has to be replaced if it's unsafe. So it was code at the time it was installed, but if it's unsafe, then the buyer can request that it be replaced. Now, if you disclose that, Francis, if you said, hey, in the seller disclosure, you say spool wiring in the home is not to code, buyer accepts it as is, something simple like that. Now the buyer can't object to it in the right to request repairs exhibit. Hope that helps. All right, let's see if I can keep going. So Teresa says, would that be addressed in the earnest money portion of the contract? It really isn't. I don't think it's specifically addressed as to who gets the earnest money, other than what it says in the form, where it says this shall automatically terminate. But I will tell you, that's how these forms work. That's how the sale contingency form works. And that's how this one works. If we can't agree to a mutual understanding of the right to request repairs, if we can't agree to extend the sale contingency and the contracts terminate, the money goes back to the buyer. I think if it was opposite, if it was to go to the seller, it would say shall be owed the earnest money as liquidated damages, but it just doesn't say that. So I hope that clarifies that a little bit. I really wouldn't overthink it, in my opinion. So let's see. I think we are probably running out of time. But I want to see if I can address just one or two other answers. But I want to just first say thank you to all of you. You can download the forms in the chat. Let's see, I'll just put that there. And then you can also watch these videos after the fact on YouTube. So many people, they sign up for this class, they want to come, and then they had something come up. So if it's this class or something else that you wanted to watch, just go onto YouTube. You can search for my name. And the series is called Down and Dirty. And don't ask me why I call it that, but you just type that into the search form. And so you'll find, Christian Ross, Down and Dirty, and you'll see my name, you'll see my face. I apologize. But then you'll see, I think I have maybe 15, 20 classes that you can look at. You can look at the new GAR contract classes that we did this year, multiple offers class, which you may want to look at, the escalation class that we did just a couple weeks ago. And we're going to keep adding them. If you got invited to this, keep coming. We're going to do more of these. And I really am excited that you guys are enjoying these. But I really wish you the best of luck in this market. It is just crazy out there. But if I can help, or if any of the attorneys or any of our staff can help here at Camel Brand, we would love to. We really just try and serve you so that you can serve your clients and your clients can say thank you to us. So it just comes full circle like that. But we'll leave it at that. There's tons of questions. I apologize if I didn't get to everything. Feel free to email me directly. My email is cross@cb.law. You can find me online as well. You can call me. We'd love to work with you. So thank you for all the people that I recognize and see, and I can't wait for the next class. Thank you again, guys.